Good morning. Welcome to the First District Court of Appeals. The first case today is Rumelhoff versus Rumelhoff. Good morning, Mr. Mead and Ms. Murray.
Good morning.
Mr. Mead, how much rebuttal time would you like today?
5 minutes, Your Honor.
Sure. You may proceed when you're ready.
Thank you. Your Honor, my name is Thomas Mead. I represent the defendant, appellant David Rumelhoff. May it please this court. We first appealed to this court in 2019. One issue presented at that time was the failure of the lower court to consider the mental health of the plaintiff, Emily Bates, during the divorce proceedings. Specifically, the lower court never acquired Emily's mental health records despite our repeated attempts via the various civil rules surrounding discovery. When the court issued its decision 2 years ago, it made an error in reading the record and denied our assignment of error explicitly on the premise that the parenting investigator in the case personally received the records. It was doubly frustrating when our application for reconsideration was also denied. The history is merely to provide a context for what follows, especially with regard to our first assignment of error. But the history is also necessary because this court has the authority to acknowledge and correct the error. Regardless of whether this court remedies that mistake, it's vital that the mistake isn't repeated.
So wait a second, you're saying that the records were not turned over for the purposes of the parenting investigation, that this court was wrong in reading the record?
The last decision states that the parenting investigator received and reviewed those reports. They were never turned over. We even went so far as to depose the parenting investigator after the last decision from this court and confirmed that he did not, in fact, receive any of the records. He only received a single letter.
Okay.
Sorry, which records are you talking about? I recall in the last case there were issues related to voicemail messages and things of that nature.
Correct. The voicemail messages were from mother's counselor at the time, and we were seeking the records, the notes and records from that counselor through, I believe she was working for what was called PPI, the Pastoral Counseling Institute or something of that nature. And those were the records at issue that we had sought. Those are the records that were never turned over and never viewed by any party within any party or the court or the parenting investigator. But
the judge found the records to not be relevant without the testimony of the therapist, right? So they were not turned over not because of privilege, but because of the judge finding that they were not relevant.
Correct. And we had filed a motion to compel her testimony. She was in Virginia. That motion to compel was denied. So
right.
It wasn't on
the basis of privilege, which is the new case that you raised. Correct.
Privilege was never asserted by the court, or for that matter, by opposing party, just to be clear. In our first assignment of error, Your Honors, we state that the court errs as a matter of law in denying and refusing to consider the merits of our motion for relief from judgment. I would emphasize the merits of our motion. In our first appeal, obviously, the Supreme Court rendered, as we were just discussing, the Friedenberg decision. And Friedenberg bears many similarities to our case because father was also seeking mental health records. Mother did appeal that decision, and the Supreme Court affirmed that the lower court made the right decision. And we felt some sense of...
But I guess going back to Judge Krause's question, if that dealt with privilege and that wasn't the issue, why the records were denied, how does that serve as a basis for post-judgment relief? Well,
it's interesting, Your Honor. The court made the determination, as Judge Krause stated, that they weren't relevant. However, the court never reviewed the records. So determining their basis and relevance without the opportunity, as we know, discovery is a broad net, is a bit of a working backwards to justify this. So from my perspective, while it's not privilege, it's still that father did not have the opportunity to avail himself of a statutory factor that Friedenberg emphasized, which is the mental health records of the other party when custody is at issue.
But this court, I mean, you raised the issue, and looking at the Friedenberg decision, that's not, like I said, it was based on privilege. That's not why the court below denied your motion to compel. we decided the issue. And I'm just having trouble understanding how you can say that Friedenberg's a true intervening decision that would get you Rule 60B5 relief.
Because I believe Friedenberg decision would change the way that the lower court was required to deal with the discovery surrounding the mental health records. Our motion to compel was denied. It's a statutory factor. Friedenberg obviously said not only is there not privilege, but that those things need to be examined by the party in that case. The lower court handled that correctly. In this case, we didn't see the records. The records were never compelled to be turned over. And moreover, the court simply, as an issuance of its final decision, just said, well, they weren't relevant anyway, after having not even reviewed them themselves.
So you're saying that Friedenberg requires a in-camera review anytime the mental health records are at issue?
No, I'm not saying that Friedenberg requires it specifically. I'm saying that Mother tried to say not only were they privileged, Mother tried to, Friedenberg places the examination of the mental health records of the utmost importance. This court did not. It didn't under the first decision, or obviously, or at the lower court decision at the time that custody determination was made. We never saw them. They were never turned over. Yes, they should have performed an in-camera inspection at the very least. I think Friedenberg made that pretty clear, that the court should always make that determination when mental health is at issue in a custody case. I think the Friedenberg language is clear on that. Your Honor, we also, again, would point out that Friedenberg obviously was disposed of just 1 month later. So I think as you were getting to that was really our justification for the intervening decision. We believe that our first assignment of error should be sustained simply because the trial court offered no analysis or conclusions pertaining to our arguments. They based the denial of our motion, and this is just the reconsideration, the motion for relief from judgment before the court, on the premise that the higher courts had already considered Friedenberg when that was impossible. And finally, because at a bare minimum, the sustaining of this error only requires that the trial court consider our motion for relief from judgment on its merits. So we believe that to be proper.
So you're just asking for a remand?
Yes.
Okay.
Regarding our 2nd through 6th assignments of error, I'm prepared to answer any questions the court may have, but in the interest of time, I'll skip over those. They were primarily with regard to the child support issue that was previously remanded to the court. Your Honors, our 7th assignment of error pertains to the court's granting of motion for attorney fees. Our contention is that the trial court ordered as a matter of law and abused its discretion when it awarded attorney fees to contrary to the journalized separation agreement, and without having considered the income of the parties, taking any testimony, or reviewing the reasonableness of fees. The record's pretty clear on how it was arrived there. I believe the transcript for the argument between the attorneys from September 9th, 2020 was submitted to this court, and that was the final entry of this court. We would cite to the Likens case out of the 12th District in Claremont, having not found good 1st District case law. It's 2021 Ohio 274. The 12th District reversed an award of attorney fees on an abuse of discretion standard where no testimony or affidavits were given, and the non-moving party had no opportunity for cross-examination. Our hearing
is it, and I guess I'm confused about the nature of your argument. Are you saying that you would have to cross-examine the lawyers involved, or is it the parties?
The parties. The parties weren't present. The parties provided no testimony. The parties didn't.
Well, what testimony would the parties provide relevant to attorney's fees?
Well, the party has, we believe that the party has to make it clear that obviously they were billed for those fees, they received those invoices, and that those fees are owing. The attorney simply saying those things without the party even being present can't establish that. And then obviously,
why can't an attorney establish that? Attorney can say that this is their bill and that they're owed that money.
They can say that, Your Honor. However, I still have no opportunity to cross-examine the opposing party in the evidentiary. hearing.
Yeah,
Did
but
you
I
have
guess
enough-
that's, yeah, sorry, that's my question though. Like what would you elicit or try to elicit from the opposing party related to that?
Specifically, we would have been able to get into the issue, I believe, in this case, Your Honors, we would have been able to get into the case that obviously the $2,288 were specifically related to motion for reconsideration and a motion for relief that we have filed regarding the communication, our alleged ex parte communication. We found those to be beyond the scope. I could have established that in cross-examination. I guess the issue, Your Honor, is rather than having to say what I would or wouldn't have done, we believe that the case law is very clear that without an evidentiary hearing, including the parties, the awards of attorney fees are generally considered an abuse of discretion.
So what occurred below? So the lawyers showed up, submitted their bills. You had the opportunity at that point to do a line by line analysis and questioning of the attorney, right? At that hearing.
Yes.
About the bill.
With Judge Seavey, yes.
And did you do that? Did you go through the bill and question the lawyer?
Your Honor, I've not gone back to reread the transcript, and I couldn't say whether or how much I questioned her on that issue. I believe there were some questions with regard to.
You're asking for an evidentiary hearing, and the key in determining reasonableness of attorney fees is to question the lawyer about their bill and go line by line through the bill, right?
That and the fee agreement, which was never provided, which I believe that the client would have had to testify to the execution of the fee agreement.
Mr. Mead, you're at your time if you'd like to reserve rebuttal.
Sure, I will stop here. Thank you, Your Honor.
Okay. Thank you. Ms. Murray?
Thank you, Your Honors. I appreciate it. I'd like to address, it seems like the one issue that they're hanging their hat on is the Freudenberg case. Number one, it was decided a year after this case was already completed. And I point out in my brief that it's not the review of the records. It's that mental health and physical health are to be considered. That doesn't say that the that the records need to be obtained. And I point out, this has already been decided. We're on our third and fourth appeal is what we're in front of you for. This was already decided on the first appeal under the 19 case number. So the continuation of trying to take a bite at the apple every time on this mental health issue has already been determined. The trial court already heard these issues, already saw the witnesses, already questioned the attorneys at that time in the trial. I think we've beat the dead horse. This particular issue is done. And there were other opportunities, as I point out in my brief as well, for them to obtain these records. They didn't take depositions. They didn't take a deposition of the counselor. If these records were so important, they should have been getting on top of it long before 2 years of trial. He claims that they had these.
But I thought he indicated that the counselor was resisting a deposition.
I don't know what the counselor was doing. Whatever the counselor, if she received the motion to compel, she had moved out of town. There were a lot of things going on at that time. My point is that these voicemails upon which he hangs his hat and requests these mental health records, he had 2 years in his possession prior to the trial even starting. So if they were so important to his case, he would have done something about it 2 years before the trial started. Keep in mind, this complaint was filed in October of 2016. We didn't get to trial until August of 18. We didn't have a decision until February of 19. So it took a long time. And if these were of such importance, there would have been other things done to obtain this information prior to that time. And you've already decided it. The court already determined it. I think this is a moot issue, frankly. I'm sorry, but I do. He's asking for remand to do what? Go back and get these records? Does he, and I don't understand the request, quite honestly, to be frank. I don't understand it. We keep wanting to go back, but really what he continues to ask in his continuous appeals is he doesn't want the judge on the case. He doesn't want the magistrate on the case. Those are his requests. Well, that's not, those also have been decided, not only by this court, but also by the Supreme Court. At some point, we all have to stand up and say that's enough, which I think leads right into his other argument about the attorney's fees. You know, to couch it in terms of it's written in the separation agreement, therefore you can never ask for attorney's fees again, takes the power, probably a bad word to use, but takes the discretion away from the court to stop continuous litigation. And those fees are part of the reason that the court issued them. I believe the court specifically said that Mr. Rummelhoff was using the court system to inconvenience plaintiff, Mrs. Rummelhoff.
So what about his argument that there was no evidentiary hearing and the parties weren't even present?
I'm sorry, I didn't understand what you said.
So what about his argument that there was no evidentiary hearing and the parties weren't present and that they should have been present for an actual evidentiary hearing to determine the validity and the amount of fees?
Well, the parties were not present. That was the judge's decision, but I was there. And as Judge Krause indicated, he could have asked me any question he wanted. He had all of my invoices. Line by line, he could have gone through them. I was sitting right there. None of that.
Well, did you actually testify, or did you just tender your invoices?
I tendered my invoices and indicated that I had incurred these fees, and that's what Judge Seavey was fine with. He didn't ask any questions. Mr. Mead didn't ask any questions.
And the basis for the fee award was under 310573B. Is that correct?
That's correct.
Okay.
That's correct. So I'm sorry, I don't really have anything to add than what's added in my brief.
I have a couple of questions about
Sure.
some of the other assignments that were not addressed by Mr. Mead. On the issue of the deviation for the child support, a couple of the reasons why the judge deviated were income potential, I believe, of Mr. Rummelhoff.
Relative financial resources, Your Honor, is that?
Yeah,
okay.
Relative financial resources, which he concluded that he could earn more. But
Correct.
there was already income that was imputed to him before. So I'm just kind of questioning how you can impute income to calculate the child support, and then you can also deviate based on the same reason. It kind of almost seems like a double dang there.
I'm not sure that the magistrate intended it that way. He was pointing out specifically things that he had taken into consideration. In his decision, he said A through Q. And that he did, so he reviewed all of those, is my understanding in reading his decision, but that he did point out that it was relative financial resources and in-kind contributions, which were two of the ones that maybe he gave more weight to. But the deviation, when we go down the next level to the deviation, you've got the 10% deviation, which is already in the child support worksheet, which he did not use. If you look at the worksheet, he didn't use the 10%. He didn't check that box. What he did in the end was in his discretion, he did the 10% plus the 147 nights. So under, is it 3119.23, he can do that. If there are 147 overnights and he didn't deviate, he has to explain to the court why he didn't.
Right.
So I would look at
that's on a separate. That was a separate line.
Separate line
right?
item. Mm-hmm.
So the other two were the potential to earn more by Mr. Rummelhoff, and then the health insurance payments by Mrs. Rummelhoff.
Correct.
But those were I guess the argument was by the appellant is that those were already accounted for elsewhere. So it almost seems like a double count.
Well, if you look at the child support worksheet that he did do. He deducts for I'm sorry, I'm talking with my hands. He deducts with the insurance that she pays on behalf of the family. But then he also changed the worksheet, as I point out in my brief, is that prior to this, he had Mr. Romelhoff paying the first $100 per child per year. He changed that, and in doing so, he's following the dictates of this court. He did the worksheet, and in doing that worksheet, he has to deal with cash medical. Well, he shifted the cash medical of $388.70 per year per child to Mrs. Romelhoff. And so technically that should have still been Mr. Romelhoff's, and it isn't. So now it's hers. So she's paying an extra little over $1,100 a year on top of the health insurance. We didn't object to it. I mean, okay, that was his in-kind. I read that as that was the in-kind contribution. She's picking up extra medical, which technically she's not responsible for.
Thank you.
You're welcome.
Anything else, Ms. Murray?
I don't think so, Your Honor. I rest on my brief.
Okay, any other questions from the panel? Okay, all right, thank you very much. Mr. Mead, you have 5 minutes of rebuttal. And you're on mute.
Sorry about that. I don't know how many times I have to make that mistake before I realize it. First, with regard to the first assignment of error, and briefly, again, I was asked before whether or not I believe the court should have conducted an in-camera. I do believe so. If the magistrate was going to determine the relevance of this, that's what an in-camera was for. That is what would square with the Friedenberg decision, and that's what was not done by this court. Without the benefit of an in-camera of any documents or materials, the court made a decision that the information was not relevant. We don't believe that the court was at liberty to do that, and we do believe the Friedenberg decision would have changed the behavior and the way in which the discovery regarding Ms. Bates' mental health records were handled. I believe I misspoke earlier. I've since gone back and looked at the transcript. Ms. Bates did assert privilege, and the court can review the record. If they look at volume 3, page 421, I believe through her counsel, she cites two HIPAA privacy rules. She goes on to state that HIPAA privacy rules, Your Honor, under 45 CFR allow them. I mean, it's very clear that they're not supposed to give those records up. This is what all therapists are relying on when they go after their records. They say, I'm not going to testify because it's a violation of HIPAA. I'm not going to give those records because it's a violation of HIPAA.
But that's not why the court ultimately refused to order the records to be turned over, though. It wasn't.
No, I was just asked, you asked me before if I believe she asserted privilege. I didn't realize she had. The court, no, did not cite to the privilege in its decision. That's correct. Specifically, you also asked about the double dipping or kind of doubling up on these deviation justifications. Yes, we would go so far as to point out that it was 2 new deviations that the court included, which were besides the fact that he kind of doubled up on both deviations, because one, Ms. Rumelhoff or Ms. Bates's insurance costs are already accounted for in the worksheet, and then he uses as a ground for deviation. And there's no other evidence that there's any other in-kind contribution made for health insurance purposes on the record beyond just the insurance payments, none whatsoever. And the same thing goes with, as the court noted, father's imputation of income. They imputed him income, and then they say that his relative financial resources were a justification, so it's doubled up. But beside that is, as we've stated in our assignment of error, that it clearly proves that the court exceeded its scope on remand. The original decision that was the subject of the initial appeal, the magistrate didn't conclude that father's earning potential constituted a relative financial resource. It's a new conclusion, and which is why we had the right to appeal and why we believe the lower court exceeded its scope. And it demonstrates how the court exceeded scope. And the question that I would pose is, if the magistrate didn't exceed scope on remand, then why is there a new conclusion that is actually contrary or seems to contradict the original decision? Because
I don't understand your argument, because we remanded it for the judge to explicitly explain the deviations. Now, whether those are correct is another story, but I don't understand. If they explained why they deviated, how is that exceeding the scope?
because the original deviation was for parenting time between the parties. He discarded that deviation entirely and picked two new deviations. And so there was no explanation. It was just a re-justification of the original support order. And we believe that it's very clear that by arriving at the exact same amount of child support and choosing two new deviations, that the court simply worked backwards.
All right. Thank you, Mr. Mead. We appreciate your argument, and thank you both for your arguments today. The case will be submitted and we will get out a timely written decision. Hope you both have a great day.
Thank you.
Good morning.
Morning to you
Good
both.
morning, Art.
The next case is State versus Cook. Mr. Hoffman, Mr. Loya, good morning. Mr.
Yeah.
Hoffman, how much time would you like for rebuttal?
5 minutes, please, Your Honor.
Okay, you may begin when you're ready.
May it please the court, Mr. Loya. I wanted to limit my comments to the topic of parental discipline this morning, and unless the court has any other questions about the other aspects of the case. In this case, the parental discipline was proper and reasonable, and it was proven by a preponderance of the evidence. I have three reasons why I make that claim. The first is that there was evidence in the body cam that shows that that this was discipline that was imposed for what Mr. Cook felt was deception on the part of SS. He felt that the boy was being deceptive and trying to do away with his meal so he could play basketball. And
Mr. Hoffman, before you continue now, this is under a manifest weight argument, right?
that is correct, Your Honor.
Okay. All right. And
And,
so this is the defense to both domestic violence and child endangering.
That's correct, an affirmative defense. And it has to be proven by preponderance of the evidence. And so these are aspects of the case that would tend to bolster that claim of parental discipline. And the first is that the discipline was being imposed on the part of what Mr. Cook thought was deception. And it's a 4-year-old child. Parents are different about the importance of this character trait in their children. Some might not pay any attention to it, but some might take it very seriously. And obviously, Mr. Cook took this issue of deception very seriously. He commented to the police officer that he was afraid it was not just an issue of the immediate correction of a character trait, but also his protection, future protection, because he thought that if SS demonstrated deception to his superiors, like he mentioned.
Yeah, and I guess I understand that at one level, but at another level, that seems a little hyperbolic. And it also seems to pave the way for justification of any sort of physical discipline of a kid, no matter what. If you start to say, well, there's a slippery slope. If I start allowing this deception or this action, the next thing I know, the kid's going to end up incarcerated.
That's the thinking of some people. Some people think that if somebody practices deception, if they're successful at it, that it might lead to that. I mean, people think that way, and parents think that way. It might scare the parent to see that behavior in their child, especially somebody that young. And and other parents may be more attuned to it. Like some parents might just give them the benefit of the doubt. Maybe the person wasn't being deceptive, but other parents it might really set off alarms with them.
Well, but my question is not, the propriety of that observation. It's more that line of thinking would allow any sort of physical, confrontation, assault, however you want to describe it, by a parent to a child. And I think, don't we have to focus on the nature of the discipline being imposed at the end of the day, regardless of the motives or how justified it might seem?
Yeah, I'm going to get to that, Your Honor. It's just that I wanted to make it clear that the parental discipline affirmative defense, it has to do with parental discipline. It has to do with that. You can't just, commit an assault on somebody and just call it parental discipline. In this case, you have a parent who is disciplining his child for a perceived act of deceptiveness. And so I'm just setting the stage. It's one of several elements that I'm going to discuss. I mean, obviously, you can't just, you put them, torture the kid, but the child. But on the other hand, the parents have a fundamental liberty interest in managing their children and caring for the child and trying to protect them in their future. And so the courts afford a lot of latitude on what kind of corporal punishment can be delivered.
There's certain factors that courts have to consider, right, when they evaluate a parental discipline defense. And I thought the judge in this case said that he thought that this wasn't discipline. This was quite severe for what is alleged to have happened. He believed the police officer's testimony in this case that described more than just a spanking, right? I mean, the slaps in the face, slamming on the car, picking the kid up by the neck. So, how did the judge lose his way in this case?
Well, I think it was the fact that the affirmative defense was proven. That's how he lost his way.
How so? I mean, you do have to look at the severity of the punishment and, the defendant's state of mind, all those kind of things.
Well, you have to look. I think it's a totality of the circumstances test now. The test has changed, but I think you'd need to look at the totality of the circumstances. And I think that whether there was an injury to the child is a big deal. But the Judge Painter and this court's decision in, I don't know how to pronounce the Adirondack, said that unless you have a risk of death, serious injury, or substantial pain, you're going to have parental discipline. That's how much latitude is afforded a parent because of this fundamental interest of parents.
Wait, you're saying that unless the child is at risk of death or serious injury, like we have to give parents a blank check to do whatever they want to them?
No. But that court, the first district case, cited another court and just said that court, a court has held that parental discipline is going to control unless there's a risk of death, serious injury, or substantial pain. And I think this is a difficult subject because when you deliver a spanking to a child, I mean, it's going to cause physical harm. Any spanking is going to cause physical harm. It's going to cause redness. I mean, under the broad definition of physical harm, you're going to commit an assault. And so this has to be an affirmative defense to that assault. You have to say that you're a parent, you're disciplining the child, and the discipline was proper and reasonable. That's the key word, proper and reasonable. And I think that this is proper and reasonable here because I'm going to go to my second and third point, and I think you should see that this affirmative defense was proven by a preponderance of the evidence. The second point was that Mr. Cook pointed out to Officer Dawson that he was disciplining SS as his father and that it was for his own good and protection. He said the child was growing up in Maysville. He was afraid he was going to have teachers that were white that weren't going to let him get away with any deception. And in the education process, deception is really bad. I mean, you need to learn. You can't be deceptive and learn things in school. And so that's the second point I wanted to make. And the third one, and the main one, the big one, is that the child wasn't hurt. And Mr. Cook knew the child wasn't hurt at the time because he claimed on that video, he said that the child isn't going to have any bruises. You're not going to find anything wrong with that child, because he knew it, because he's his dad. He knows how to discipline the child without hurting him. It was not a face slam or whatever the officer said. I mean,
well, but like putting him on the hood or some part of the car that is sitting in the sun and that is hot. I mean, that's probably more severe than slapping the kid, because that can cause serious injury.
The testimony was that as soon as the child called out that the car was hot, and that was incidentally was the basis for the scream that the officer heard, Mr. Cook immediately took him off the car. That part was an accident. That was not intended. That was not a form of discipline to hold the child on a hot car. That was not it. That was an accident on his part. That's unfair to try to tattoo him with that conduct when that was peripheral. It wasn't a direct consequence of this discipline that was being delivered.
Mr. Hoffman, you are at your time if you'd like to reserve 5 for rebuttal.
I would like to do that. I asked that the court would reverse this conviction, and thank you.
Okay, thank you. Mr. Loya.
Thank you, Your Honors. May it please the court. This court should sustain the defendant's convictions for domestic violence and child endangering. The state has met all of its elements and met the burdens as requested. Now, quickly briefing onto it, during the argument, his only argument prior to this was that there was not show of harm. We believe the testimony of the officer that the child was struck several times, lifted up and slammed onto the car that was hot at the time, then struck again, is enough sufficiency to prove that harm was caused and that the child was placed in risk of danger or of severe harm. Moving on to responding to the defense's arguments of child endangering, however, the defense makes several statements based on that the child's age and that this was only for discipline. However, it was not reasonable, and considering the factors that should be considered by this court, such as the child's age, the behavior that was trying to be corrected, what was done, what corporal punishment was done, and what steps were taken prior to corporal punishment that have tried to, it cannot be seen as reasonable in any way. The child was 4 years old. According to the defendant's own testimony, he was being deceptive that the child told him that he had finished his chicken nuggets. And in that way, it warranted that he would grab the child, strike him twice in the head, lift him up, slam him onto the back of a car that was hot at the time that the defendant knew or should have known. He testified that he was aware of the heat and how hot that car could get, and then struck him again. And his demeanor during that time, he was angry, he was upset. He was yelling at the child, yelling at the officers. When his brother came up and asked him to try to talk reasonably so that people would understand him, he continued to yell at his brother.
Can I ask you though, so we have a charge of child endangering under 2919.22a, and that says that a parent shall not create a substantial risk to the health or safety of the child by violating a duty of care. What was the substantial risk in this case?
Your Honor, I believe that the substantial risk is the risk of causing severe harm to a child. He is a 4-year-old child. He slapped him in the head, lifted him up, and slammed onto a car. That act alone is substantial risk of physical harm.
Why wasn't he charged under the B section, which is basically a child abuse section? No person shall abuse the child.
Your Honor, as to why he was not charged under the B section, I believe at the time that it was filed and was taken forward, I believe that it was chosen to go forward under the A section as it was charged, as it seemed like it would have been met regardless, since the charge of domestic violence and the second charge of assault and the charge of child endangering, if you found those two, you would follow naturally that you would have to find the child endangering as well.
Okay. But the substantial risk, even though there was no injury to the child. I know the paramedics came to check him out. They didn't see any kind of problem. And I'm just wondering if this was an appropriate statute to charge him under.
Your Honor, I believe the substantial risk simply implies that it does not require that harm actually be caused. In fact, the statutes as written none of these statutes as written indicate that harm in any way needs to happen. Only that risk of harm.
Well, a substantial risk.
Yes, a substantial risk, but that's what I'm understanding. And I believe it's based on the officer's testimony. When you take a 4-year-old child, when a grown adult takes a 4-year-old child and slams him onto the hood of a car or any part of a vehicle, after striking him, then strikes him again, that is a substantial risk of harm to a child. Now, going on from that, Your Honors. Now, moving on from that, as far as that goes, the child's age, basically, the defendant has, when considering the factors of what prior steps have been taken, the defendant was very clear in his testimony. He stated repeatedly, "I will whoop his ass any time. I've whooped his ass in the past. I whooped his ass earlier with his grandparents' house." He never once, that just shows on indication that he has not taken any step other than striking this child. In fact, it would go further when he's striking, when he's on his attacking the child, harming the child with family members, they have brought to his attention that he has gone too far. He mentions that right there, that they have brought to his attention that his discipline goes too far. It is not discipline, this is abuse. And his response to them was to mind your own business. And that he could do whatever he wanted. He could do it whenever he could whoop his child's ass whenever he wanted. This was not reasonable discipline. The sheer fact the child was lucky enough not to suffer any harm at the time, or at least not visible harm, should not weigh against that. The fact that his actions were abuse, they were an assault. He did commit domestic violence. Now, and Your Honor, I know you mentioned that the EMTs mentioned, however, that testimony was properly objected to and sustained. And the First District Court has held in the past that it not to review further state testimony, even if it was on video, that was objected to and sustained and kept out. So the hearsay testimony of the EMT officers, of others involved, should not be considered at this time. Now, Your Honor, going further on, during the defendant's cross-examination and during his direct examination into speaking on the car itself, he indicated that he was aware, or should have been at least aware, he knew how hot that car would get. He knew how long it had been sitting out there in the heat, and that car was going to be hot. And even knowing that, he still chose to place the child. He might have pulled the child off, but he still made that decision that he would put the child on top of the car, knowing, or should have known full well, that car would be hot and cause harm to that child. And in fact, did burn that child so much that he screamed out. All right. Based on these, the affirmative defense simply cannot work. And based on this and the testimony of the private officer, there's no way a judge could have lost his way to manifest weight argument. They will provide adequate testimony, show that this wasn't, the judge even said themselves, that based on what they heard, this was too severe. This went far beyond any reach of corporal punishment or parental discipline. And as the court is at the time the court is the best trier of facts for what is credible or not, we would ask that this court sustain the convictions for the domestic violence and child endangering. Any honors?
Okay, thank you. We appreciate your argument this morning. Mr. Hoffman, you have rebuttal time.
Please, the court, it's true that the testimony regarding the Officer Dawson testified that the EMT was going to testify that the EMT checked out SS and found that he was okay, and it was objected to, and the trial court kept it out as hearsay. But at the same time, the videotape was admitted into evidence, and the whole thing was viewed by the trial court. And it's the same scenario if one witness was going to testify to hearsay and it's objected to, and then another witness testifies to the same thing without any objection. That testimony is in evidence. It's fine. It's unobjected to. And the only difference here is instead of a second witness, you've got a videotape. And so
I don't think there's any dispute. I mean, it seems like it's undisputed that the child didn't have any physical injuries that were observed.
Okay.
Right.
I was going to say that the trial, this is unusual in that both sides of the case admitted the same videotape. And before the trial court announced that he was going to watch those things. And so this isn't a situation where you have a videotape that may or may not have been seen by the trial court. He said he saw it. And so all the things in the videotape, both sides thought there were things that would help them. It's open season as far as I'm concerned, as far as all the information in the videotape.
But it almost seems like what you're arguing is that unless there's some sort of physical injury that you can see, then a parent can't be guilty of disciplining or hitting their child. I mean, that seems to be what you're resting your argument on, is just because he didn't have any lasting physical injuries that anyone could observe.
Well, it says a lot, because if the handling looked as bad as it did and he wasn't hurt at all, then that dad knew what he was doing. He knew how to discipline a child without hurting him, which is a big deal.
Psychological harm, does psychological harm?
Well, if you get into that, I think, I mean, this was a municipal court case, so you don't call experts every day in municipal court. But there was zero evidence about emotional harm. And another thing, it might be that the power of suggestion might be bad. Some parents might bring up children like this all the time, and the children, it may be emotionally fine with it until somebody thinks that they're being abused, and then the children might be like the sentencing they mentioned here, the child being afraid to go to bed. I didn't know, there was no timeline on that. It might have started after he saw his dad get arrested for what he did to him. I don't know. But I think that's to try to bring that into this, I think is wrong. To try to say, well, there's a risk of emotional harm. For 2000, I mean, I don't know how many thousands of years people have been disciplining their children, but I don't know
how many thousands of years those kids have been going into therapy.
Okay, well, that's why we're having this discussion.
Right.
There wasn't any harm, and some parents, I guess, know how to, put the fear of God in their children without hurting them, and I think that might be the case here. It might not be the way we would discipline our children, but he's still a parent. And when that Officer Dawson said, who is he to you? He said, that's my child. And that's a big deal. And then he even rhetorically asked the officer, who are they to you? And the officer didn't really have anything to come back on that one. I mean, a parent has to have a lot of latitude on how they discipline their children. It's a fundamental right to bring up your children and manage them the way you want. And so I think that that's the reason for the affirmative defense. And that affirmative defense was demonstrated in this case by a preponderance of the evidence. It didn't look good. What he did alerted the officer to step in. But at the end of the day, he's a parent and he's got a right to discipline his children the way he thinks he should, as long as it's proper and reasonable. And I think under the totality of the circumstances in this case, mainly because the child wasn't hurt at all, and he looked fine when the officer approached, wasn't even upset, wasn't crying, that affirmative defense was met in this case. I'd ask that this court reverse the judgment and send it back for a new trial. Thank you.
Thank you. Thank you both for your arguments today. The case will be submitted and we'll get out a timely written decision. Hope you both have a great day.
There you are.
We lost Judge Myers.
Yes, we did. I'm going to try to get her back. I will pause the stream.
Okay.